Welcome back. This afternoon, we'll first hear an update on implementation of the Racial Justice Act. As I also mentioned, we'll then move on to some quick administrative updates, hear from staff about issues we've considered at earlier meetings. Then we will take public comment, and after public comment, we'll make final decisions on what recommendations will be in our 2024 annual report. All right. But first, we're going to hear about the Racial Justice Act. This update will be provided by Belle Yan, who is assistant professor and supervising attorney at the University of San Francisco School of Law's Racial Justice Clinic. She'll give us a short presentation and then we'll have Q&A afterwards. Our goal with this presentation is not to make any recommendation in this year's annual report, but to get a general sense of what's happening with the RJA and see if we want to consider anything more closely next year. With that said, Belle, please take it away.
Thank you, Chair Romano. Can you see my slides?
Yes.
Great.
As we just, we haven't had many guests today, but as you know, the same admonition that we give to everybody, which is we've read what you've said before, we appreciate it, and also we'll take 5 minutes, and the best part of our conversation is usually during the Q&A period.
Okay. Thank you, Chair Romano. My name is Belle Yan, and I'm an assistant professor and supervising attorney at USF Racial Justice Clinic. In addition to teaching and supervising students, I litigate retroactive RJA cases and facilitate an RJA implementation working group with members who are attorneys, academics, and advocates for system-impacted community members. Today, the theme that comes to mind regarding RJA implementation is that procedural hurdles are preventing claimants from litigating the merits of their case. I'll first discuss the scope of the RJA litigation that's happening now, highlight some current challenges that claimants and practitioners are facing, as well as discuss the challenges that we expect to be greater hurdles as more RJA evidentiary hearings are held and opinions are issued. And lastly, I will offer some suggestions that this committee may want to consider in the future to assist the legislature in addressing some of those challenges. As a quick overview, the RJA was enacted in 2021 and has been amended twice to include a 5-year rollout to allow people charged and sentenced in criminal cases to raise RJA claims depending on the posture of their case. Since 2021, there have been 15 published cases, including one decided just last week. I will not go through them all, but these cases illustrate the scope of the issues that have been touched upon, as well as a spectrum of issues that have yet to be addressed. Some of these cases address the sufficiency of evidence necessary for a motion for relevant evidence, or known as a D motion, and an RJA motion to reach an evidentiary hearing. Some cases have addressed the forfeiture of an RJA claim, or the possibility that condemns claimants from them filing an RJA claim without forfeiting their other habeas rights. A very small handful of cases were about the merits of their motion, and retroactive claims have also raised interesting questions about the timing of litigation and who is qualified to raise those claims. The statute outlines 4 paths that allow someone to raise RJA claims. 2 are best categorized as conduct-based violations. You may hear me talk about them as A1 or A2 claims, and the 2 other are disparity claims, like we shown with data and other evidence, and these are known as A3, A4 claims. All 4 of these claims were anticipated to be brought in both prospective and retroactive cases. Because of the rollout of RJA application, these issues can be raised in both appellate and resentencing cases. With prospective RJA claims, there hasn't been any official tracking. Trial attorneys are able to raise RJA as a pretrial motion with formal pleadings, as well as an oral objection during proceedings where something comes up in the middle of trial. Anecdotally, there's been dozens of RJA motions filed and only a handful of completed evidentiary hearings. Often, an alternative disposition, like a prosecutor's dismissal of the case or a favorable plea offer, ends the case after the filing of a motion or before a hearing. It is also unclear how many retroactive claims have been filed. There's no clear tracking system for retroactive claims either. When attorneys have approached the court about how many pro per RJA petitions they've received, the answer is we don't know. But what we do know is that over 92,000 people are incarcerated at CDCR. Based on the work from organizations like Ella Baker Center and Silicon Valley Debug, thousands of people have requested and received information about filing and developing their own claims. At USF, where we process intake forms from people incarcerated who identified and outlined their claims for possible legal representation, we received over 650 intake forms since last year and received many more letters requesting assistance. A judicial officer has estimated that one of California's larger counties expects 7,000 retroactive claims. Again, we don't know, but this is what we've learned anecdotally. Currently, significant barriers of sufficient pleadings have hindered disclosure of relevant information for claim development and appointment of counsel. Courts are also inconsistent in allowing claimants to bring their claims by petition or by motion. And as discussed earlier, appellate courts have reckoned with RJA claims and issues. And in the context of recall and resentencing procedures, courts have raised questions about their authority to hear RJA claims at that stage. And in this presentation, I'm not touching on death penalty cases at all, but some issues that have come up for those particular cases is funding for counsel, as well as successive claims and habeas petitions. Here are some of the procedural challenges claimants encounter when trying to litigate RJA claims. Some that I want to highlight is, again, the retroactive cases. There is a confusion about whether a claimant can bring a motion or petition, despite Penal Code Section 745, subsection B, stating that a claimant may raise either a motion or a petition. Forfeiture has also become a significant issue for cases in all procedural postures, which prevent RJA claims from even being heard. And another issue is whether failing to raise an RJA claim in recall and sentencing proceedings waives that potential claim. In other words, this raises a question about whether the scope of the counsel's representation when they are appointed for the limited purpose of resentencing. In addition to hurdles preventing claims to be heard in court, there's also significant challenges in developing claims. As this committee has previously heard, data collection and analysis are particularly difficult. Even when courts grant motions for relevant disclosure of evidence, disclosure of relevant evidence, the time that it takes for that data to be disclosed can be in the units of months or even years, which is particularly problematic when the claimant is incarcerated. This is an issue in both prospective and retroactive cases. Availability of appointment of qualified counsel is also challenging. Many retroactive claimants cannot receive assistance from the public defender's office in the county of their conviction. Those claimants are left to investigate their own claims, and even if there were a pool of pro bono attorneys who could assist with the investigation and drafting, there are questions of who is qualified to be appointed in those petitions. And lastly, we've also noticed that all stakeholders in RJA implementation could benefit from future training. And lastly, because of the hurdles in developing or raising RJA claims in court, challenges in determining the merits of the cases have not been fully realized. As attorneys are researching and drafting arguments around the RJA, here are some questions that have come up, some that we expected to be difficult. Two issues that were raised in the Mosby case is about the meaning of similarly situated and when can the court consider as race-neutral reasons. Though Section 745, subsection H6 clearly states that comparison groups are not to be, quote, identical, the factual analysis that was considered in Mosby raises questions about what comparison group members should look like. These questions will remain until claimants in misdemeanor, felony, and capital cases can receive the data they need to put their claims together, analyze that data, present their findings, litigate these issues in court through evidentiary hearings, and if successful, receive relief. In this presentation, I hope to describe the scope of RJA litigation as it is currently, and highlight some of the challenges that have existed in its implementation. The RJA was enacted with the legislatively articulated reason that, quote, race plays no role at all in seeking or obtaining convictions or in sentencing. While those subjected to the criminal legal system continue to seek relief, significant hurdles have hindered those claims. Though the appellate court have provided limited guidance on its interpretation of the statute, here are some suggestions that this committee could consider in the future when it's time to revisit the RJA. They go directly to the heart of developing and bringing claims, clarifying pathways in accessing courts and justice, and ensuring relief when a violation is found. Thank you for your time and attention, and I'm happy to answer any questions you may have. And I got scared with the 5-minute comment.
Excuse me? Sorry.
It was
Uh,
okay. You
I,
mentioned
I have
5 minutes, and I was like, oh no.
um there's some noise in my house. Um I'm not quite sure where to begin. Is it true? I believe it's the case that there has been no disparate impact case that has even come to an evidentiary hearing. Is that correct throughout the whole state?
I believe that there has been two that have come before, at least two that have come before superior courts on the trial level. One is in San Francisco, where the defendant's last name is DeCure. And in that case, the court found that there was not enough to sustain an RJA violation. There is another claim in Contra Costa County where I believe the defendant's last name is Wyndham, where the court did find that there had been a disparity claim met. And I believe the remedy in that case was that they removed the special circumstances.
So those are the only two cases. What was the Santa Clara case was a special circumstance murder case, and what was the case in San Francisco?
There is one in Contra Costa and there's one in San Francisco.
Oh, I'm sorry. So the Contra Costa case was the special circumstance, and what was the case in San Francisco?
That also was a special circumstances case. In that case, the accused was somebody who was female and Black, and that was a murder. It was a murder robbery.
Got it. Well, I think that my general interest begins with the idea that this is a really, the statute as you read it, as one reads it, is very compelling, and you would think provides a great avenue for relief and to address many of the concerns that I think that we all share about the justice system. Yet it's very difficult to actually prevail under the claim or litigate under the claim. And actually, it's been around for several years, but nobody's been able to be effective. Except for that one case, it sounds like in Contra Costa County. Um, I do think that we should consider this further as a committee. I'm just not quite sure what further we can do today. I don't know if folks have questions or thoughts for Professor Young.
Yeah, I have a question. Can you talk a bit about the barriers to accessing data? Obviously, that is a prerequisite for the disparate impact claims under the RJA, and to what extent statewide data collection would remedy those issues. That's my first question. My second is, can you talk a bit about cases that have been decided not on the disparate impact theory, but under the disparate treatment theory? Are those cases moving through the courts at a more rapid clip, or are they being bogged down with the same sort of evidentiary issues that the disparate impact claims are experiencing?
And two, I'd be happy to answer those questions. To clarify, when you mentioned disparate treatment, are we talking about the conduct-based violations, the A1 and A2s?
Correct, exactly.
Yes. I'll take your first question, which is about data collection. Um, Data collection is an issue that is making these A3 and A4 claims incredibly hard to litigate, even through requesting data from D motions, which are the motions to disclose relevant data, as well as doing Public Records Act requests to both well, not both, but the DOJ, CDCR, as well as prosecutorial offices and law enforcement. There has been significant pushback in trying to receive that data. Some of it is, some of the explanations that we've received is that they're not able to provide the like line by line data. So often what practitioners are trying to show, for example, in a plea offer is how does the case kind of track from people being arrested to people who are being charged to people who are getting offered pleas and then people who are going to trial and being sentenced. And there's not really one agency right now that has all of that information. And so practitioners and claimants are trying to get data from all these different parts of the criminal legal process. Some other challenges have been really just the historical data. As you know, the retroactive claims for the RJA are currently ripe, but people have been incarcerated at CDCR for 20, 30, 40, maybe even 50 years. And to receive data, to look for data that is from that time period where prosecutors' offices or other agencies understandably did not have the technology to track the data by computer makes it exceptionally difficult for them to um, provide the data in the kind of the data spreadsheets that we need today to be able to do that kind of analysis. Other issues that have come up around the data collection is that even though multiple people could have an RJA claim with the same asking for the same charges with the same time period, but courts have been issuing protective orders. So even though the data could be accessible by public records request, that client and those attorneys are not allowed to share that data with any other clients in the pursuit of their RJA claims. So that's just additional litigation that has to happen.
Can I ask you a question about that? What is the
Of course.
justification for the protective order?
My understanding is that in some courts, there has been arguments from the prosecution that the data results from work product privilege. There also are questions about, because of Mosby and the factual analysis that occurred in Mosby, there claimants are also asking for police reports to provide that factual analysis for those comparison groups. And so there's information in those police reports as well. Part of it is that those police reports could be redacted, and sometimes they are redacted, and courts are still issuing protective orders around those police reports for that factual analysis.
One of the problems that has come up, and correct me if I'm wrong, is that you not only need to find everybody who's convicted or sentenced under a particular provision, but it's anybody who could have been convicted or um, sentenced under those provisions. So they're quite expansive, and you need more than just sort of conviction data, which is, a big problem. I was wondering, Professor Yan, if you're familiar with the Supreme Court ordering the order to show cause case out of Sacramento County. I think it's Haney is the defendant's name or the petitioner's name.
I'm only familiar with the name, but unfortunately, I'd have to come back to the committee to talk more about that case. But I
Okay,
did.
it caught our attention because Haney was a pro se petitioner who petitioned the violation of the Racial Justice Act on a retroactive claim using data that we published, using committee data published about the three strikes law, and the Supreme Court issued an order to show cause, which we found to be it seems to be tantamount to finding of a prima facie case. So now issuing an order to show cause isn't a full opinion, so it's difficult to sort of read too much into that. But I think hopefully let me put it this way. The Supreme Court seems to be interested in this issue, seems to be looking out for it. I don't know if we can read too much into the Haney case, but I do think it's another reason for us to try to look into its implementation and see if there might be legislative interventions that can facilitate, I think, what was the clear intent of the law.
I appreciate that, Chair Romano. And I want to go back to Professor Ocean's question about the disparate treatment as well. Professor, I would say that there has been, so the Bonds case goes to the merits of a prima facie case. when it comes to disparate treatment. That is one of the cases that have been published. I would say that there has been a I would say more of the evidentiary hearings that I know of in California have been disparate treatment cases. Defense attorneys have been able to retain experts who talk from in sociology, criminology, and other fields and bring that expert to court and talk about what that explicit or implicit bias looks like and why that conduct is explicit or implicit bias. So based on my understanding of RJ implementation now, I would say more of the hearings have been on the A1, A2 claims. But again, because there is no tracking and there's 58 counties where they're not an equal reporting and participation in these spaces like implementation groups, I don't have an answer for you, an accurate, a complete answer for you.
Right.
Thank you.
And it does make some sense that the A1 and A2 conduct cases have come to hearings and are a little bit more discreet and I think probably easier to litigate. But they aren't the systemic disparate impact cases that fall under the A3 and A4 categories.
Yes, and I would note that when I talk about the claims being heard, we're only talking about prospective cases. As this committee, knows, in retroactive cases where a claimant has an A1 or A2 claim, it must arise to the level of overcoming the harmless error rule. And that creates particular challenges for retroactive cases as well, even when there was explicit and implicit bias that is in the record.
All right, well, I think that you've accomplished the mission that I think you've piqued our attention.
Excellent.
I mean, given our calendar and the way that we work, I don't think that we don't have enough information right now to make a recommendation, and because that would have to be done today. But I do think that we should take a deeper look into this next year in our calendar and develop recommendations that might help facilitate these claims. I'm particularly interested in the disparate impact claims because I think one of the animating features of the Racial Justice Act was to address the United States Supreme Court case in McCleskey versus Kemp. And so far, my reading of what's been going on is that it has been excruciatingly difficult, if not impossible, to litigate those cases in any meaningful way, despite, I think, all of our concerns about the racial imbalance in the justice system. So, unless anybody else has anything more to say on this, I think we should move on. All right,
Like,
Professor Young, does somebody want to chime in? All right, Professor Young, thank you so much. I really appreciate it. It's good to see you again. I'm sure we'll be in touch.
yes, thank you. And I appreciate your consideration and your time. Thank you, everyone.
We will be in touch.